We've been around since 1996 when we first began fighting for a legislation for right to information. The present preoccupation with corruption is not a new one. For instance, the right to information also tried to tackle corruption and arbitrary governance. This is for all of us a maturing of the right to information into a different concept of the Lokpal. So it has been something under debate and discussion for a long time. The issue of corruption itself is much too simplified today in the public domain. It's not just merely financial corruption, it's also the arbitrary use of power. It's the use of power to bring in policies which bring in inequality, which bring in division, which bring in oppression, suppression. It's all those. So while we are quite clear that a Lokpal is needed to look at financial corruption, we must understand that the promise that one law will satisfy or solve all issues is completely, I think, mistaken. So our Lokpal, which looks at the practicality and the principles of delivery of justice, of access, of bread to the common person, and of the right to establish a corruption-free governance, which means actually that we enjoy the fruits of independence genuinely, is defined in the basket of measures which the NCPRI has prepared. Corruption is both an ethical and a political issue. If we should circumscribe it in either of these paradigms, we make major mistakes. The issues of corruption range from small little problems of very small households of ordinary people to huge scams. So to bring it under one umbrella is always a huge problem. The only thing we can bring everyone under is a demand that corruption should end, which is an ethical issue. The moment we talk about solutions and we talk about political ideologies or reasons for corruption, we are bound to have differences of opinion. When it comes to drafting of a law, the same kinds of perceptions or other perceptions are bound to intervene. So you cannot have even the so-called civil society formation, one law or one draft which is universally acceptable. So the debate that is on today at many levels is, can there be a law which answers all problems, and can there be just one legitimate or correct perception of the law? We question that, because if people ask to dissent from a government law, then we must have enough space for dissent amongst people who want to frame an alternative law. The second issue is that it is true that in the pre-legislative process we should have space for people to form draft legislations, to discuss those legislations. But once it goes into Parliament, then the legislative process has its own sanctity and its own special privileges. If we tamper with those privileges, the net result of that kind of tampering will be delegitimizing a process which will ricochet on all of us. We really feel that three things. One is that we need to look at the law in terms of size. So we feel any large law which encompasses everything has two sets of problems. One is the problem of the scope. You bring in a scope of contradictory forces and people who may need the law to be decentralized. Some will need decentralization. You need to keep independence of certain structures from each other. So it creates a mess. So we need to have parallel institutions which will deal with corruption. You also need to separate grievances, which is a completely different structure from the structure of corruption. So this is the division we've made. Corruption on the one side, which has subsidiary institutions which will deal with all kinds of corruption. Grievances, which is a different genre to deal with issues of normal everyday issues of everyday people. Then we have a whistleblowers bill which will deal with all the issues of people who protest within the system. I want to state that this has nothing to do with the National Advisory Council.
We feel that the Lokpal itself should tackle high-level corruption. which would include the Prime Minister, but with certain caveats. For example, we feel that if the Prime Minister is to be investigated, it must be a decision of the full bench of the Lokpal plus a full bench of the Supreme Court. Should not be investigated for vicarious actions, but only things that the Prime Minister has done himself or herself. Certain issues relating to security, etc., could be kept out of the purview of investigation. We feel all ministers, we feel all MPs, we feel that for the moment the constitutional privilege given to MPs that they cannot be investigated for matters done or spoken inside the House can be allowed to remain. But sooner rather than later, this constitutional amendment should be brought about so that that can also come under the purview of the Lokpal. And senior civil servants, Group A. We feel that as the Central Vigilance Commission or CVC, which is currently looking after Group A officers, will then have little work because they'll be shifted to Lokpal. So Group B and other officers would come under the CVC. Now the CVC needs to be revamped, made more independent, given investigative and prosecutory powers, etc., and adequate staff. The CVC will become the first complaint place for large corruption among the junior staff, so something which is maybe involving more than 10 lakhs, etc. For the remaining, it will become the first appeal if a proper investigation is not done by the police or the other authorities. We also feel that this way all the civil servants will get covered. Corruption of the judiciary would of course go under the Judicial Accountability Commission, which would be separate. We are worried about the fact that if you take away from the government all its role vis-a-vis the prevention of corruption, then in some senses there is no answerability to people about corruption, because the Lokpal institution will be an independent institution. It's not elected by the people, it's not answerable to the people, it's not answerable to the parliament, it's answerable to nobody. Therefore, we feel that it is important that at least some role of the government remain. We don't want these institutions to be therefore dependent on the government, but we like at least in junior staff to let the government have a first go at preventing corruption. Now finally one can ask, why is it that you want this division? We want this division because there are, for example, over 40 lakh central government servants at the moment. Common perception is that at least half of them are corrupt. Even if they do one corrupt act a year, that means 20 lakh complaints a year. Now, in order to handle 20 lakh complaints a year, given the current norms of the CBI, you would need something like 7 lakh investigative officers, because they only do 3 to 4 complaints in a year. It's impossible to run an organization that size. We are also insisting that there should be parallel similar institutions at the state levels. So the Lokpal at the center will have correspondingly Lokayukts at the state. And the Central Vigilance Commission at the center will have parallelly state vigilance commissions at the state. Similar parallel function.
We believe in the NCPRI that judges of all levels must be covered by a mechanism which is established by statute for tackling corruption. However, they cannot be treated in the same manner as other public servants, because there is something very important that is mentioned in the Constitution called independence of the judiciary. It's important to ensure that the judiciary remains independent of external influences, and a mechanism is created for tackling charges of corruption against judges, keeping that principle in mind. So what does the Judicial Standards and Accountability Bill do? It's a bill introduced by the Government of India in Parliament. Parliament is, through its standing committee, studying it for improving it. We in the NCPRI believe that certain improvements are necessary. The first thing is the appointment of the National Judicial Oversight Committee, which looks into complaints received against judges. That is a government-dominated committee. We are saying it must be changed. It must be made not dependent on the central government or any of the state governments. It should be appointed in a manner that is transparent and participatory, and that which is not government controlled. The second thing is, right now the bill creates a 3-tier mechanism for tackling charges of corruption filed by citizens. What we are saying is, let it become a permanent structure, let it be based at the central level in the capital. Now, this bill talks about vexatious complaints, and anybody who files a frivolous or vexatious complaint, if proven, can be sent to jail and also be imposed a heavy fine with. We think this is unnecessary. If it is shown that a complaint was made, it was disproved, but yet the complaint was made with malified intent, only then there must be a fine. Sending a person to jail will only discourage complaints coming from citizens. The next thing that we are suggesting is, in this bill, there is a provision for imposing minor penalties on judges who are found guilty of charges which actually do not warrant their removal through an impeachment process. Right now, what it does is, it only requires giving an advisory or warning to any judge who's been found guilty of a minor misbehavior. What we are suggesting is it should be expanded upon. The Law Commission had suggested that there should be things like forcing a judge to retire, or also taking away judicial work from the judge for a certain period of time. These kinds of provisions should also be brought in. At the same time, just because a judge has retired, there should be no reason why the complaint inquiry process must be suspended or stopped. We are saying it must continue even after the judge's retirement if the process is not complete. And the last point that I would like to share is that there is a need for a similar accountability mechanism to cover judges in the lower judiciary, because that is where corruption pinches the common man the most.
The NCPRI version of a grievance redress bill, what it should contain, has been developed, and in that we are essentially saying that every government office, every government authority has to bring out a statement of obligations, where it should clearly lay down all the obligations of that particular office, and what are the goods, what are the services, what are the entitlements that that authority has to provide to people. It has to clearly lay out the responsibilities of each government official in that department. What are they supposed to deliver in, and what time frame they are supposed to deliver it in. So, for example, a ration card has to be made. The process for getting a ration card made, how much time it has to be made in, who's eligible for getting that ration card, who's the officer responsible for giving that ration card, in how much time it should be made. All of this has to be put out, for example, in a statement of obligations. Under the formulation that the NCPRI is proposing, there would be a decentralized structure. It will be a 3-tier structure that we are proposing. At the office level, at the public authority level, each public authority will have a grievance redress officer. This officer will be responsible for taking grievances of people and redressing those grievances in a very clear time-bound manner. In case the officer is unable to take care of that grievance, or the citizen who's complaining is unhappy or dissatisfied with the response, the complaint can be escalated to the next level. The next level that we are proposing is at a district level, where a district grievance redress authority will be set up, and this authority will actually look at all the cases in which people can go in and appeal against the grievance redress officer. Should the grievance of a complainant not get resolved even at a district level, then it will be escalated to the Public Grievance Commission, which will be set up both at the state level and at the central level. The PGC, the Public Grievance Commission, and the District Grievance Redress Authority will both have powers to penalize people who are responsible for not addressing a complainant's grievance. And they will also have the powers to compensate the person who is aggrieved for the inconvenience that they have had to go through because of the grievance not being redressed. One of the things that we've proposed in this formulation is that there should be a public support center which should be set up at every block in the country, or in an urban center at every ward level. The reason is that from experience, people feel that if they go to a department to file a complaint, they're often not entertained, their complaints are not accepted. So in order to make this whole process people-centered, people-friendly, this support center we felt was critical, and it has been included. It will actually help anybody who wants to file a complaint and help them track their complaint once it comes into the system.
if you look at the NCPRI proposals, the Lokpal and the Jan Lokpal, it will become very clear why the NCPRI has come up with this more democratic, Loktantrik Lokpal. If you look at government's Lokpal restricts itself to 65,000 people, does not include the Prime Minister, but does not include the rest of governance. It is certainly something that's very serious, because one does need to look at higher level corruption, but one also needs to look at the concerns of other people. The Jan Lokpal seeks to deal with the concerns of all other people, but if you think of it, can you have one body that deals with, from the Prime Minister to the peon, deals with corruption of the 2G scam kind and of the everyday corruption, the transactional corruption that takes place with the Patwari or the Babu or the police officer or the constable? Can one institution, and is it wise for one institution to deal also with the judiciary, all members of parliament, higher bureaucracy, lower bureaucracy? And what is the size of bureaucracy that's going to come under this particular body, that's going to have to deal with a person in Manipur and deal with someone in Delhi, a postman and his complaint, right? Can we really sort out the problem of corruption if we set this up? Corruption comes from the arbitrary use of power and abuse of power. We are setting up an even more powerful agency to try and sort this out. So are we not causing another agency that may end up being even more corrupt? And will we come 2 years from now to ask these questions? So these concerns have to be addressed, and the best way we felt it had to be addressed was to break it up into its specificities, so that the judiciary can deal with its own issues with an independent body, which won't be a huge bureaucracy. It will just be a body looking at the whole judicial structure as a kind of a commission which is there in an existing bill. What needs to be done for the higher bureaucracy is very careful looking at each particular deal. What needs to be done for grievances is within a month every citizen should have a solution within their district and not have to come to the national capital or the state capital. And most importantly, you cannot have a powerful police officer sitting in every district or every block, because that person, if today's police officer is corrupt, what is to prevent that other police officer from becoming corrupt? So we have tried to say, let us produce something that will cover all these issues, but not empower the state more, but empower people more.